The purpose of this presentation tonight is based upon a statute that the Illinois legislature passed that went into effect on January 1st of 2022. And what that statute allowed the public to do, homeowners, homeowners associations, condo associations, what it allowed them to do is it gave them a process to remove a restrictive covenant that's otherwise unenforceable, but still is on their records. And maybe that is very distasteful to some. So it gave a process to do that. It was done pursuant to the Illinois Human Rights Act, so that came into play. And there were restrictive covenants that were typically based on race, national origin, religion. This statute sought to be able to remove those sort of things. I'm going to come up later, I'm going to tell you the process that the state's attorney's office is going to use. You're going to hear from Doreen Pollack, who is the chair of the real estate section of the McHenry County Bar Association. And Joe Tirio is going to come up and tell you the process that the recorder's office, and Joe Tirio is your McHenry County recorder, that office is going to use before it comes to the state's attorney's office, and then we send it back to Joe. So hopefully at the end of tonight, you'll have a really good idea what the process is going to be to remove these restrictive covenants if a homeowner or in a homeowners association, condo association wants to do that. So without further ado, Doreen, come on up.
As Norm identified, my name is Doreen Pollack. I'm an attorney here in McHenry County, and today actually marks the anniversary of the 30th day, or the 30th year, since I began practicing law in McHenry County. So it's 30 years, Norm, that we've known each other. But I'm not here to talk about that. What I am here to talk about are restrictive covenants, and specifically unlawful restrictive covenants. As we saw in our video, and as I believe to be very true, home ownership is a significant aspect of the American dream. It's a symbol of success and achievement. But what happens to that dream when someone tells you that the home that you bought, the community in which you live, people that look like you were once not welcome? What does that do to your dream? We cannot erase history, but what we can do is we can try to prevent future wrongs. So seeking modification of unlawful restrictive covenants is one way to address this issue. And that's in essence the statute that Norm referred to earlier. That's what that allows a process to do. So let's start at the beginning. What is a restrictive covenant? The Black's Law Dictionary, surprisingly, has a very short definition of it. It's a provision in a deed limiting the use of property and prohibiting certain uses. So that begs the question, where do you find restrictive covenants? Typically speaking, you're going to find restrictive covenants in one of three places. They're either going to appear on the face of a deed, which is the document that conveys ownership of property from one person to the next. They may appear on a plat of subdivision. In other words, when they mapped out, these are the lots and this is where your home is located, within that document itself, which is recorded in part of the official record, there may be certain restrictions included there. Or you may find them in a declaration of covenants, conditions, and restrictions of record, such as governing documents for homeowners associations. So when you purchase your property, you know you're part of an association, you know that there are certain rules and regulations to abide by. Those documents that set forth those rules are where you may find those restrictive covenants. So that then leads to the question, are all restrictive covenants unlawful? And the answer unequivocally is no. In fact, most restrictive covenants that you and I are going to see in today's world are not going to be unlawful. There are going to be things, for example, that limit the use of the property to residential use only. They may place limitations on architectural design. They may limit your ability to construct a fence or have a dog run. They may prohibit you from parking a boat or a trailer in your driveway, or there may be other similar restrictions that are imposed upon your land, your property on which your home is located. Those are not unlawful restrictive covenants. Those are perfectly allowed and, in fact, will continue to be allowed. So if you're here to get rid of those covenants so you can park your boat in their driveway, this is not the place for you to be. So what then is an unlawful restrictive covenant? The act referred to earlier by Norm, or statute, is Public Act 102-0110, and that's the subject of our presentation. It defines unlawful restrictive covenants as any recorded covenant or restriction that is void under Section 3-105 of the Illinois Human Rights Act, which purports to forbid or restrict the conveyance, encumbrance, occupancy, or lease thereof on the basis of race, color, religion, or national origin. So that act in and of itself refers to the Illinois Human Rights Act. The Illinois Human Rights Act further defines it as every provision in an oral agreement or written instrument relating to real property which purports to forbid or restrict the conveyance, encumbrance, occupancy, or lease thereof on the basis of race, color, religion, or national origin. Those are considered to be void, as are any conditions, restrictions, prohibitions, which include a right of entry or possible reverter, which directly or indirectly limit the use or occupancy of real property on the basis, again, of race, color, religion, or national origin. So there are unlawful restrictive covenants out there. I want to try to put them in a bit of a historical perspective. I'm not a historian. This is simply my understanding. So fact check yourselves, but based on my research. About 1915, in our country occurred what was often referred to as the Great Migration. This was a time during which black Southerners who were seeking to escape Jim Crow laws moved to the Northeast, the Midwest, and the West Coast from their southern states. Basically, they were seeking to avoid the restrictions that were being placed upon them by virtue of those Jim Crow laws, and were seeking a better life, or the American dream. In response to this influx of black Americans, racially biased and discriminatory restrictive covenants began to appear, and they gained popularity. This was in an effort to prohibit those blacks from moving into white communities. What was their motivation? Your guess is as good as mine. Was it hatred? Was it fear? Was it greed? Or was it the prestige of living in an exclusive community? Regardless of the motivation, beginning about the 1920s, restrictive covenants came into vogue and became very popular. There were actually even organizations out there that had the boilerplate that they were selling to people. This is how you do this in your community. Obviously, this was wrong. And as often happens with wrongs, these cases come before the courts. And in 1948, the Supreme Court of the United States rendered such restrictive covenants unenforceable in the case of Shelley versus Kramer. The case of Shelley versus Kramer involved a black family, the Shelleys, that, unbeknownst to themselves, purchased a home in an area in a district in St. Louis that long before they purchased it, 30 out of 39 property owners in this specific district signed an agreement that prohibited property in that district from being occupied by any person not of the Caucasian race. Interestingly enough, when the Shelleys bought this property, there were, in fact, black families that not only lived in that district, but owned property in that district. And in fact, there was one family that owned the property 30 years prior to this covenant even being signed by those 30 property owners. In fact, their ownership of the property dated back to 1882. So there was nothing to tell the Shelleys that, hey, you are not wanted here. This is not an area where black families can live. The Shelleys bought the property from a willing seller who was obviously not concerned about enforcing these covenants, and they went to move into the property. And that's when one of the owners of those 30 other properties, not even a neighbor to the Shelleys, said, not only do I not want you here, but I'm going to file suit to prevent you from being able to take possession of your property. And he did. The trial court did not enforce the restriction, so he then took it up to the Supreme Court of the state of Missouri. And the state of Missouri actually found that that covenant was in fact enforceable. The Shelleys found it necessary to appeal the matter to the Supreme Court of the United States. They concluded that restrictive agreements, standing alone, cannot be regarded as violative of any rights guaranteed by the 14th Amendment, so long as the purposes of said agreements are effectuated by voluntary adherence to their terms. However, in granting judicial enforcement of the restrictive agreements, as was done by the Missouri Supreme Court, the Shelleys were deprived of equal protection of the laws that is guaranteed by the 14th Amendment. Quick constitutional refresher. What does the 14th Amendment provide? No state shall deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law. So basically, what Shelley versus Kramer, or with Shelley versus Kramer, the U.S. Supreme Court found that although racial restrictive covenants were not void per se, a court cannot enforce them because doing so would constitute state action and would therefore be violative of the 14th Amendment, thus rendering them unenforceable. So in essence, what that court case meant was that individuals were still free to draft restrictive covenants, to place restrictive covenants of record as it pertains to their property, but if somebody wanted to actually enforce that covenant, they couldn't bring it to the court to try to enforce it. Because of this, even after the Shelley versus Kramer case in 1948, you still saw restrictive covenants that did become of record during that time period. And that continued up until 1968, when the Fair Housing Act outlawed restrictive covenants by prohibiting discrimination based on race, color, religion, sex, or national origin. And, as I mentioned earlier, the Illinois Human Rights Act also renders such covenants void. Which then leads to the question, if these unlawful restrictive covenants are unenforceable, and if they are void by the Fair Housing Act and by the Illinois Human Rights Act, why are we here? The answer, although they are unenforceable and void, they remain on the books and by their own terms run with the land, meaning when you buy the property subject to those restrictive covenants, they're still on your title per se. Case in point, I'm going to apologize in advance to anyone that I may offend, but I'm going to read to you from a deed. It's originally dated June 22nd, 1941, and this is a deed that is for the Deep Springs Woods subdivision, which is located here in McHenry County. And this deed, from which I'm about to read, was actually recently discovered by Craig Crandall, who many of you know is also an attorney here in McHenry County. It's very small print, which I blew up, so I'm going to have to take my glasses off and squint. I thought about doing it as a slide, but you would not have been able to read the print, so forgive me for that. But the deed itself conveys the property from one party to another, as is common. I'm not going to mention the names. However, the conveyance of the property is subject to the following restrictions and conditions. Number 1, no dwellings shall be erected on said premises that shall cost less than the amount approved by the Wonder Lake Syndicate or its assigns, such dwelling to be only of the single-family type and must be erected before any other building or tents in place on said lot. I'm skipping some parts. Number 2, that any garage erected on a lakefront lot shown on said plat shall be attached to the dwelling. No outside toilets shall ever be erected on the plats or neighborhood. Number 3, said property shall be used for residential purposes only. Number 4, the grantees shall have the perpetual right to the use of the community parks in said subdivision, subject to the rules and regulations of the grantors. Number 5, the grantees agree to become members of the Lot Owners Association. Number 6, the grantees are given the right to use Wonder Lake for recreation purposes, including hunting and fishing. Number 7, the grantees are to permit no refreshment stands or amusement enterprises on the property unless said lot is designated as business lot herein. Dance halls and the sale of alcoholic beverages are prohibited on these premises. Number 8, no signs are to be erected in or on the above premises. And then I'm going to skip to number 10. Just want to make a quick comment. Every single covenant that I read to you just now, those are lawful. Those are things that are absolutely still to this day within the right for property owners to impose on land, for homeowners associations to impose on their subdivision, for creators of plats of subdivision to impose. This next part is not. The ownership and occupancy of the premises herein described are forever restricted to members of the pure white race, and no Jew, Negro, mulatto, Chinese, Japanese, or person of any race or mixture of race other than a person of the pure white race shall be permitted to acquire title or possession to the premises herein described, or the improvements located thereon, or the right to occupy any part of the premises herein described as owner, tenant, renter, or otherwise, except that the white owner or white tenant may permit his domain servants or servants not of the pure white race to occupy a room or rooms of his said dwelling or garage building during such time only of such domestic service. This is technically still of record. By their language, these covenants run with the land. So, what do? How do we get them off the books? That's where the statute comes into play. Public Act 102-0110 became effective January 1st of this year. It is a legislative, proactive measure that codifies a process by which parties can file a restrictive covenant modification to remove unlawful covenants. So let's go through what this statute allows. First of all, who can execute or record or seek to record a restrictive covenant modification? Per the statute, a person who owns property which is subject to an unlawful restrictive covenant, or a common interest community association, condominium association, unit owners association, residential housing cooperative, or master association of parcels subject to such unlawful restrictive covenants can seek to modify those covenants. Question number one then becomes, how do you know whether or not property is in fact subject to an unlawful restrictive covenant? How do you find out? My short answer is, it's not easy. It's very unlikely in today's day and age that when you purchase real estate, the unlawful language is going to be obvious. It's not likely going to appear on any of the documents you receive in closing. As I mentioned earlier, you're going to see restrictive covenants generally in one of three places, either on the face of the deed, the plat of subdivision, or the homeowner's governing documents such as the Declaration of Covenants, Conditions, and Restrictions of Record. When it comes to the deed, today's deed is not going to include the language such as I just read to you. Today's deed is only going to have a general reference, if any, to subject to conditions and restrictions of record. So you're not likely going to see it there. When you're buying your home, you're not likely to look at the plat of subdivision that created the subdivision that you're purchasing in. You also do have access to covenants, conditions, and restrictions of record, but the question is, A, how much attention did you pay to them, and B, is what the homeowners association provided actually reflect all covenants historically, and do they include such unlawful restrictive covenants? One place to look, since as I mentioned, you're not going to see it on the deed, a place to look to at least give you a hint as to whether they may be out there is going to be your title commitment at the time of purchase or the title insurance policy after you purchase. They're not going to include the language themselves. In fact, there's probably going to be a disclaimer within the title commitment or title policy, which would say something along the lines of any provision contained in, attached, linked, or referenced in title commitment that under applicable law illegally discriminates against a class of individuals based upon personal characteristics such as race, color, religion, sex, national origin, etc., or any other legally protected class is illegal and unenforceable by law. So what you will see on a policy is you'll see a reference to a specific document that has the year it was recorded and the recording number as a reference. What you're not going to see is the language itself. However, using such references, you can dig and you can find these, and that's where that's most likely what you're going to have to do, to be honest. But I'll give you a hint. First of all, as I mentioned, there are certain years that are important in regard to these unlawful restrictive covenants. 1948, the Supreme Court makes them unenforceable. 1968, Fair Housing Act makes them void. 1975, Illinois Human Rights Act makes them illegal. If your home was built after 1975, and most likely if your home was built after 1968 and the subdivision was platted after 1968, you're probably safe. If your home was built before the 1950s, that's where you really need to start looking for these things. So the best hint is, again, to look at the title policy or title commitment, see what references there are, and then utilize a local title company. We have Katie O'Neill's here from Heritage Title. She'll talk to you a bit about that in a moment. Or utilize the recorder's office. They are the ones who have these records. First of all, you're going to need to determine whether or not there is such a unlawful restrictive covenant that affects your property. And then once you make that determination, you're going to need the document itself. So once you make that determination, what do you do? As an individual homeowner, you can take action on your own. If it is a subdivision as a whole, I strongly encourage you to take action to force your association to take action so that it affects not only your individual property, but the subdivision as a whole. When you talk about the association, keep in mind, however, that only a board acting on behalf of a majority vote can in fact execute and file a restrictive covenant modification. Board being defined by the statute as the board of managers or directors or managing trustees of such association or cooperative. You as an individual who lives within that association, however, has the right per statute to make a written request to your board to in fact take action. If in fact an individual homeowner makes such a written request to the board has 90 days in which to investigate any claim of any unlawful restrictive covenant. As I mentioned, it takes some work to find them, so give the board some time to act on it. And if in fact they determine that there is an unlawful restrictive covenant, the board, again, acting by vote of the majority, can take action itself to then have that removed. Say, for example, you as a homeowner have reason to believe that these covenants are out there that impact your home. Deep Spring subdivision, I'm looking at you. You can go to your association, you can request that they take action. 90 days passes, the association fails to do anything. The statute allows you to take action to force the association to do so, and that would be by legal action itself. So there is something in the game for the homeowners association to do so. They can be sued if they fail to do so. When they do, however, assuming that the association takes action, they are required to provide written notice to all owners or members of the association or cooperative of the restrictive covenant modification together with a copy of the restrictive covenant with the modification itself. So let's talk about the modification. What exactly are we talking about? You need a complete copy of the instrument that contains the language with the unlawful restrictive covenant. On that copy, it is up to you as the petitioner to strike out that which you are seeking to remove. So again, this is not your opportunity to say, I want to park my boat in the driveway, I'm just going to cross that part out, or I really want a dance hall here where I can serve alcohol and cross that part out. So you get a copy of the document, you strike the unlawful language, you file that with a certification that includes a specific reference to the parcel identification number or unique parcel identification code. In other words, you have to identify the property that this impacts. And this is the part that I love, any other information that the recorder or state's attorney's office considers necessary. So you as the owner or the association on behalf of the subdivision as a whole gets the document, you strike the language, you file the petition. Next step is it goes to the recorder's office, and Mr. Tirio is here to talk a bit more about that process. Recorder's office then turns it over to the state's attorney's office. Norm will address this in greater detail momentarily. State's attorney's office has 30 days in which to review the document to determine whether in fact the document itself includes unlawful restrictive covenants, and if so, if the modification that you're proposing correctly strikes through only that unlawful language. And if they then determine it to be appropriate, it goes back to the recorder's office where it is then recorded and of record. The process that I described seemingly should be simple. To make it even easier, the statute allows for a limitation on what the recorder's office can charge you to, in fact, file the restrictive covenant modification. $10. So it's not a circumstance where it should be costly to the homeowner as an individual or to the association as a whole. That's one of the reasons why that limitation is included within the statute. The bottom line is we cannot erase the sins of the past. But what we can do is erase them for future generations so that when they purchase property, their dream of owning a home does not have to be subject to the taint that is the unlawful restrictive covenants that says you once were not allowed here.